Good evening, everyone. I'm Sherrilyn Ifill. I'm the Vernon E. Jordan Jr. Distinguished Professor of Civil Rights at Howard University School of Law, and I'm also the founding director of the 14th Amendment Center for Law and Democracy. In fact, I'm coming to you right now from the 14th Amendment Center here in Washington, D.C. And tonight we're beginning the first in what will be an academic year-long series of webinars on the 14th Amendment. It is such a powerful and important provision of our Constitution. It is much contested, and it is in the news almost every day. We think it's important that not only law students and lawyers, but all Americans have a deep and historically based knowledge of this important amendment to our Constitution that shapes so many of our lives. We're offering these webinars for free to give all of you an opportunity to understand when you hear these issues in the news and when you hear people talking about issues related to the 14th Amendment, that you will feel you have some facility to be able to understand what's at stake. The first webinar is a two-part offering on birthright citizenship. That's birthright citizenship. Tonight, we're going to explore a great deal of the history that surrounded the drafting and ratification of birthright citizenship and the influences that shaped the concept of birthright citizenship in the 14th Amendment. And then tomorrow night, we'll be joined by another set of scholars, and we'll explore the way the experience of Asian Americans in the United States as it relates to immigration and to citizenship has helped us understand and has been a powerful example of the meaning of birthright citizenship in the 14th Amendment. So thank you all so much for joining us tonight. Please get ready, get your pens out and your papers. Those who have been my students in the past know that we move briskly, but I also want you to know that we are going to share all of the resources with you at the end of the webinar and maybe throughout the webinar even. We'll be placing some links in the chat so that you can get these resources yourself in original form. And after the webinar series, we're going to send out a kind of post-school syllabus that will have the sources that you need to be able to ground yourself in the discussions that we're going to be having over the next two nights. The 14th Amendment is what historian Eric Foner calls the most consequential addition to the Constitution after the Bill of Rights. It is the longest amendment to the Constitution, and I hope we can get it up on screen. It was so long we had to use 2 pages. It has 5 sections, and they are chock full. I will tell you that even most lawyers are not fully familiar with all 5 sections of the 14th Amendment. And in law school, I recall, we only really learned about Section 1 and Section 5. Tonight, we're going to focus on a provision of Section 1, birthright citizenship. But let me first say this about the 14th Amendment and why it is so consequential and important. It was ratified in 1868. This is after the end of the Civil War. There is an understanding that the end of the Civil War means the need to stitch the country back together. And part of that stitching involves integrating fully into full citizenship in American life the 4 million Black people who reside in this country. This is critically important because the first Constitution, that's our original Constitution, the one that was written and founded by James Madison and Hamilton and Jefferson and all those folks that you all are familiar with, even if only because you saw the play, made a number of political compromises, and many of those compromises were the compromises that related to the enslaved population as a way of accommodating the desire of Southerners to continue the institution of chattel slavery, which was critical to their wealth. Some of you know about the 3/5 compromise in Article 1 of the Constitution, the compromise that apportions and that determines how individuals are to be counted for purposes of congressional representation. The 3/5 compromise essentially says that those who are enslaved will be counted as 3/5 of a person, not as a whole person, for purposes of representation. The purpose of it was to not allow Southern states to have the benefit of counting enslaved people who could not vote and had no political rights as a whole person, but also to give them something that allowed them to add to their numbers from this enslaved Black population. Another provision of that original Constitution continues the slave trade until 1808. It's sometimes hard to find in the Constitution because the word slavery does not appear in that original Constitution. Instead, they call it the importation of persons, clear evidence that they knew that the concept of slavery was contrary to the spirit of the document that they were drafting and preparing to adopt. After the Civil War, we now needed to deal with those compromises and make the nation whole and give it an opportunity to live up to what it purported to be. The first thing that was necessary was ensuring that Black people could be citizens of this country. Now, this was a task that involved overturning a Supreme Court decision, the Dred Scott versus Sanford decision, which many of you may have heard of, in which the Supreme Court in 1857, led by Chief Justice Roger Taney, who you see on the screen now, Roger Taney of the state of Maryland, held that Black people could not be, were not and could not be citizens of the United States. In that opinion, Justice Taney said that Black people had no rights that the white man was bound to respect. And by saying that Black people not only were not citizens, but could not be citizens, the Dred Scott decision not only ensured the continued slavery and non-citizenship of people who were held in bondage, but also rendered the free Black people living throughout the country stateless persons. And so the question of citizenship was vitally important. Now, remember, the 13th Amendment, which ended slavery, had already been ratified in 1866. It enshrined the concept that there could not be involuntary servitude except for punishment for crime or treason. But what this meant is that even though the population now was no longer enslaved, they were not citizens, and therefore there was the concern about some of the rights that those who were stitching the country back together in Congress, the radical Republicans, could confer on formerly enslaved people. Would they have the right to trial by jury? Would they have the right to make contracts? Would they have the right to purchase real estate? Would they have the right to serve on juries and so forth? There was a Civil Rights Act that Congress attempted to pass and did pass, the Civil Rights Act of 1866. But the then president, President Andrew Johnson, who had been President Lincoln's vice president, and who himself was a white supremacist. He was against secession from the Union, but he believed in the inferiority of Black people. He vetoed the Civil Rights Act of 1866. Congress overcame that veto, but it became clear to them that if they wanted to protect and ensure the citizenship of Black people, they would need to do so by a constitutional amendment, which could not be merely overturned by successive Congresses or by a presidential veto. The first line of the 14th Amendment, if we can go back to that slide, attempts to do the work of ensuring the citizenship of Black people. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state where they reside. That one sentence is doing so much. First of all persons born or naturalized in the United States. Not all formerly enslaved people, not all Black people, all persons born or naturalized. That is the provision of birthright citizenship. And subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Let's go to the end of that sentence. Citizens of the United States and of the state wherein they reside. This is the federal government making a determination that being born in this country confers both national citizenship and state citizenship. It's also interesting that national citizenship comes first. It is an assertion of the primacy of our national citizenship over our state citizenship. Much has been made of the words "and subject to the jurisdiction thereof," and indeed it is those words that has been the basis upon which there are current challenges to birthright citizenship. But the question of what those words mean was firmly and fully decided by the Supreme Court in 1898 in a case called Wang Kim Ark versus the United States. And in that case, the child of Chinese migrants who was born in this country, that is an American-born child in this country, the question, the controversy was that child a citizen? And indeed, the Supreme Court found that that child was a citizen. They engaged in the same conversation that we are seeing today about what subject to the jurisdiction thereof means. And the court determined, looking at the legislative history, that it means precisely what the framers meant for it to mean, which is that it did not include the children of diplomats who are still subjects of their foreign country. That's why we have things like diplomatic immunity. It meant children who are born in prisoner of war camps to enemy aliens who are being held as a result of war. And of course, it meant Native Americans who want to hold their tribal citizenship and not be US citizens. And we'll talk more about in coming sessions about Native Americans and their citizenship. So Wang Kim Ark decides the case in 1898, and that's where it stands, and everyone has understood that to be the law of the land. But about 15 or 20 years ago, we started to hear as policy questions overturning birthright citizenship. Let me be clear, under our constitutional structure, a constitutional provision can only be overturned by either another constitutional provision, like how the first sentence of the 14th Amendment overturned the 3/5 compromise, and Section 2 of the 14th Amendment overturns the 3/5 compromise, or by a different interpretation by the United States Supreme Court. President Trump earlier this year issued an executive order which purports to carve out an exception to birthright citizenship, deeming those children who are born to parents in which neither one of the parents is either a permanent resident or a citizen to not be a citizen of the United States, even though they were born here. As you can imagine, there was immediate litigation that was filed. 22 states have filed suit challenging this executive order. Individuals have challenged the executive order and organizations that represent immigrants. Every district court, federal trial court that reviewed the complaint issued an injunction, a nationwide injunction. An injunction is an order that stops a party from doing something or compels a party to do something. In this case, to stop this administration from applying their executive order until the case moved through the system. The administration took that issue up to the Supreme Court, not the issue of whether birthright citizenship extends to these people who are identified in the executive order, but whether the district courts had the power to issue nationwide injunctions. This has been an issue that has been of tremendous interest and concern to conservative legal scholars and actors for some time. And the Supreme Court decided to take up that issue and use this case as a vessel to determine that district courts do not have the authority to issue nationwide injunctions. The court then sent the case back down to the district courts. In those district courts, the parties now had to grapple with how to move forward with the case, and they decided to take up a suggestion that had been made at oral argument that the cases could proceed as class actions. Class actions are actions that are brought among aggregated claims. That is, many plaintiffs come together who have the same interest and who have a common issue with regard to a particular law or policy and bring the claim together. Several cases involving class actions were filed. Those classes were certified, injunctions were issued. And so even though the district courts do not have the power to issue nationwide injunctions pursuant to the Supreme Court's decision, they can issue injunctions on behalf of the class. And so that's the posture of those cases in this moment. They have not been decided on the merits. They are still in the district courts. We expect these cases to move forward and move up through the United States Supreme Court. The consequences of the court deciding this case are huge. I will say the mere fact that the court did not dismiss the claims out of hand, or even at the oral argument indicate beyond the three more liberal justices, Justices Kagan, Sotomayor, and Jackson, who talked about the consequences of allowing this kind of challenge to a constitutional provision. The other justices were silent on this case, on whether or not the merits of this case warranted moving forward. That in and of itself, I find troubling. In any case, we expect this case to come forward this year, and it's important that every American understand the significance of this. In case you're thinking this is about other people and not about you, every American needs to understand that the birthright citizenship provision is about all of us. Fortunately, tonight, we have with us some true experts. I can't imagine any experts who would be better at having this conversation with us tonight than the two scholars who are with us. Kate Masur, who is an historian. You know what? I like to get people's titles right. So the John D. MacArthur Professor of History at Northwestern University. She is a scholar of the 19th century, a scholar of this period, and deeply steeped in an understanding of the forces that influenced the Congress that wrote the birthright citizenship provision. We're also joined by Martha Jones, and Martha Jones's title is incredibly long. Society of Black Alumni Presidential Professor, Professor of History, Professor at the SNF Agora Institute, and Director of Graduate Studies at Johns Hopkins University. She is a prolific scholar, the author of numerous books, also a scholar of this period. I really want to commend to you the works of these scholars that relate particularly to this subject. Kate Masur's book, Until Justice Is Done, Until Justice Be Done, America's First Civil Rights Movement from the Revolution to Reconstruction. It is so good. It really helps us understand the process, the decades-long, the 100-year-long process of coming to the conception of citizenship. And then Martha Jones' amazing book, Birthright Citizens, which is the Bible, A History of Race and Rights in Antebellum America. These two scholars have two newer works as well. Kate Masur has a graphic, we don't call it a novel, graphic book, Freedom Was in Sight, which is co-authored with Liz Clark. And I wanted to get the postscript, but my eyes are so bad that I couldn't say the rest of the name of the book, which is Freedom Was in Sight, A Graphic History of Reconstruction in the Washington, D.C. region. So for my DMV people, really essential and incredibly accessible and wonderful book. And Martha Jones's new book is The Trouble of Color, an American Family Memoir, a very personal journey about race, color, and family. Thank you both for being with us, and we are going to move right into the conversation. Okay, so first of all, I want to talk a little bit about this idea of how we come to concepts of citizenship in this country, and particularly through the 14th Amendment. And I think many of us have been led to believe, because when we have been taught about framers of the Constitution, we assume it's the people sitting in the room drafting the provisions. We think of it as the members of Congress or the legislators. We don't think of all the ways in which those individuals were shaped and influenced. And in the context of the 14th Amendment, to take a posture of looking at the framers as only those legislators necessarily leaves Black people out of the conversation of how these concepts were shaped and developed. And so I thought we'd begin with you, Kate, and ask you to begin, excuse me, Professor Masur, and ask you to begin talking a little bit about the subject of your book, about these movements that are happening from the revolutionary period onward that are beginning to shape the conception of citizenship.
Sure, and thank you so much. And please call me Kate also. Yeah, I mean, there are many ways to begin this question, but I love how you're setting it up. And we can even start with our own time. People who are experts, people who are sitting on the considered experts sitting on the Supreme Court or the most elite lawyers are not the only people who have views on what the United States Constitution is or should be. And the same was true in the 19th century. And so, you know, in my book, Until Justice Be Done, I explored how African Americans, particularly free Black people in the North, where the states in the North were gradually abolishing slavery and there was a growing free Black population in the North, began to think about the ways that think about their rights and think about the ways that many white Americans were interested in abridging their rights, right? So we're talking about people who were already free. I mean, setting aside, which you can't really do, the people who were enslaved, which was the vast, vast majority of Black people in this country. But free Black people were thinking, well, you know, about the ways that the Constitution, in their view, and the Declaration of Independence also guaranteed them certain rights, guaranteed them citizenship, and yet there were these developing forces in the United States seeking to deny them that citizenship, to cast them as non-citizens. I wouldn't even say second-class citizens, but non-citizens. And so they began to develop an interpretation of the Constitution that said that they should be considered as people born in this country, as free people born in this country, citizens of this country, that rights should equally apply to them as white people. And over time, and we can get into more detail on this definitely, they developed a certain number of white allies who were with them for a variety of different reasons, and then, you know, for complex reasons. And so going forward, you know, there was never a time, I mean, we begin in our brief with the 1790s. There was never really a time that the United States was an independent country when Black people were not talking about themselves as citizens. But with growing momentum after the 1820s, they are increasingly organizing and developing this kind of stream of thought about their own citizenship and putting it out there in public, in newspapers, having conventions, and that their ideas about their own citizenship directly impacted the debate, largely happening among white people white men who were the only voters in this country, largely began to impact the debate that leads into what you end up seeing in the 14th Amendment. So I'll stop there, but there's obviously so much deeper we could go with all of that.
Sure. I wonder, Kate, let's just do a little bit of level, a little bit deeper, just maybe even you mentioned conventions. And here I think you're talking about the colored conventions. We had a wonderful opportunity to have kind of the foremost colored conventions scholar, Gabriel Foreman, with us when we launched the center, and that's another book we will highlight, and we'll put the information in the post syllabus. But just to talk about what it means, what was a colored convention, and what do we take from what they were doing, what they were talking about? How were they communicating to the public their ideas about citizenship?
Sure. I mean, should I continue or?
Yeah, no, please go ahead.
Yeah. So we're learning more and more about the Black Convention movement, although it's been something that historians have been looking at for quite some time, but it's increasingly visible in part because of the work of the Colored Conventions Project, which, you know, hopefully we can provide more information about that. But so Black Northerners and some Black residents of kind of the Upper South, places like Baltimore and Washington, D.C., from 1830 onward, organized very deliberately in what we now call colored conventions. They called themselves that at times as well. But we're talking about meetings that would happen. Sometimes there were annual national Black conventions. Sometimes there were state level conventions. So we see many, many different state conventions, sometimes again annually, sometimes there would be breaks, sometimes there were regional conventions. And so what the conventions then, one of the reasons we know about them is because they often created recorded minutes, which they published in pamphlet form. They passed resolutions. Sometimes their proceedings or parts of them were published in newspapers, whether Black newspapers or sometimes white newspapers. And so sometimes we have letters in some cases of people writing back and forth personally about the conventions. Frederick Douglass was involved in the colored convention movement, although this movement was enormous and absolutely, he's the best known figure, but certainly far, far, far from the only one. And so what the records of these conventions amount to is this vast trove of information about the political and social thought of Black Americans, or at least many Black Americans in this time period. And this is where, among other things, because they didn't only talk about citizenship, they talked about a whole range of topics of interest to themselves. But among them was their views, were their views on the Constitution, on the Declaration, on what their own role in this country was. And sometimes they issued statements directed at white people, right? So they weren't, some of their conversations were internal about, well, what do we as Black Americans want? And sometimes they were saying, here's an address to the so-called the citizens of the state of Ohio, in which they meant white Ohioans. Here's what we want to say to you. There are addresses to Americans and saying, look, here's what we want Americans to know. And these were out there to some extent, as I said, white newspapers as well as Black newspapers published them. And we have to keep in mind it's a really different media environment from now, where there's huge diversity of newspaper publishing. So this was not a secret that they were having these meetings. What they were saying, what they were talking about was widely known among white people as well as Black people.
And they were very involved in petitioning, which,
Right.
when you don't have power is one of the ways you kind of let your views be known. And many of those petitions were sent to the Congress that was, grappling with and engaged in hearings about the 14th Amendment. So they're part of the record, right, of
Exactly.
those
That
who were
is
actually trying to figure those provisions out.
right. So that's another way that we know what they were doing, and another of their political strategies, in addition to kind of using media to get the word out, was to petition both the US government, the Congress, and also state governments.
Mhm. Professor Jones, I wondered if you might say something about kind of the leading public intellectuals, writers, abolitionists, and so forth, and their contributions as public intellectuals is probably the best way to describe it in modern times, but how really influential and important they were, and here both men and women.
Yeah, also from me, thanks very much for convening us and for um, making this conversation possible. I think the first thing I want to underscore is why the history that Kate Masur has just shared with us is so important in this moment to us in the present, because in the administration's challenges to birthright citizenship has been built in the assumption that the 14th Amendment and its birthright provision was intended to remedy a very specific question, and that was the question of the citizenship of formerly enslaved people. And so part of what Kate and I have been, I think, very committed to is a reframing that reminds us that there were free Americans, Black Americans, who were living pursuant to a constitution that drew no color line, and yet were subjected to a color line when they were variously denied the rights and the privileges of citizenship. So who were some of those folks was your question. And Kate, I think has already mentioned Frederick Douglass. And Douglass is, of course, today one of the best remembered thinkers and statesmen of this period. And in addition to, I think, Douglass's better known work as an anti-slavery advocate, is the role he plays very deliberately and very regularly through, for example, the colored conventions movement. And so we can find Douglass, particularly in his home state of New York, but also in national conventions, speaking to this question. Are we, as free Black American citizens of the United States? And the answer is yes. I think one of the maybe most fascinating figures from this story is Martin Delany. And Delany was a journalist, he was an abolitionist, and he was indeed among those leading Black thinkers who took on the question of citizenship. He was, as Kate suggested, someone who read the Declaration, read the terms of the Constitution itself. The president must be a natural born citizen of the United States. And men like Delany say, if the president is a natural born citizen, aren't we? And there is no color line in that provision or any other provision of the Constitution. And so you can see someone like Delany building up an argument that ultimately rests on the Constitution and rests on this broad fact of birthright citizenship in the United States. Why Delany is so interesting is that by the 1850s, he is profoundly despairing. The anti-slavery movement is not having the force that its proponents had hoped. Black laws, colonization, I think we'll get to those things, but other efforts to suppress free Black Americans are only growing in their force. And a new Fugitive Slave Act has made it possible for slaveholders to reach into the free states and, in essence, kidnap free Black people and call into question not only their citizenship, but their status as free people. So Delany, by the early 1850s, is working up momentum behind what he refers to as an emigration movement. He is beginning to encourage Black Americans to leave the United States. But when we read him, it is heartbreaking because Delany understands what he is giving up. He believes himself to his core to be a citizen of the United States. He believes Black Americans have earned their citizenship by virtue of their labor, of their military service. He understands that Black Americans have an affective relationship to the United States. He says, this is where our fathers and our mothers are buried. And so Delany, even as he is contemplating leaving the US, and he is not alone in this, he never gives up, right, the insistence that he is a citizen of the United States. You asked me about women, and I must mention Frances Ellen Watkins Harper, a great Baltimorean whose 200th birthday we are celebrating in just a week. Frances Harper is a poet, an abolitionist, and one of the most eloquent speakers on the anti-slavery circuit in this period. It is tough for women to take the floor at the colored conventions. It is more possible for women like Harper to pick up the pen. And so we know a great deal about her thinking. And she too tells her audiences that indeed their sights cannot be limited to the all-important freedom, though there is that, right? That their sights must be set on the high bar, right? And the high bar is citizenship without compromise and without qualification. Frances Harper wins audiences even as she is unorthodox because she is indeed a poet, and so lends that kind of quality of speech to a political debate that is, of course, of deep concern for all Black Americans, not only the men who we remember so well.
You know, I think one of the greatest examples of why dissenting opinions in the Supreme Court can be so important is the dissent of Justice Ketanji Brown Jackson, in which, you know, as she begins to take on this kind of originalist argument about the 14th Amendment, decides to cite to the colored conventions, right? She basically is advancing an argument that is very much grounded in what you all are describing, that when even if we are to take on the narrow framework of a pure originalist argument, An originalist argument should compel us to continue this part of the history that you all are describing, that is very much part of that original understanding and part of the original influences that resulted in the language that we see. And I just want to take a moment for that. Just that jurisprudential moment is so important, because that's ultimately what we're fighting for, right? Is the ability to more expansively understand and see and hear the voices that were heard at the time in different fora and that shaped and influenced these provisions that we're debating about today. There's so many things I want to get to. I just want to very briefly take 5 minutes on Black sailors. You both write, obviously, in your co-authored amicus brief. The link will be in the chat at the end of this discussion. It is absolutely brilliant. You both write about it, but individually in your books, you write about the experiences of Black sailors. And I did want to read, just to give people an example of how threatening Black sailors were thought to be. I want to quote from an 1841 issue of the New Orleans Commercial Bulletin, in which the editors say that Black sailors are the worst, I'm quoting, the worst evil that threatens the peace of the South, a people most dangerous to our institutions, committed to carrying on the work of insurrection and massacre. So why don't we start with you, Martha, and then we'll go to Kate. Why would the editors of the New Orleans Commercial Bulletin deem Black sailors so dangerous?
Well, on this debate about citizenship, Black sailors present sort of the very real material challenge to the ways in which, as Kate alluded to, in the US before the Civil War, citizenship is a patchwork. It is uneven. Right? A Black sailor can board a ship in Boston, pull into the port at
where he is a citizen of
where he is a
Massachusetts.
Citizen of Massachusetts, and arrive in the port of Charleston and be required either to remain on board ship or to be jailed or detained. And sailors begin to press this question.
And with the threat of potentially being sold into slavery, right?
Absolutely. So are we citizens of the United States with rights equal to others? Or is it possible that this is a nation, right, that can slice and dice citizenship in ways that are so perverse, right, that free men can be at risk of being detained, jailed, and even re-enslaved? Now, the other thing going on is that for a long time, Black sailors had been understood correctly, right, to be the agents of news, of communication. And so, again, those pamphlets that are being produced by the colored conventions, those newspapers that are being printed in the North are thought to, and in many cases are, making their way to Southern ports in the satchels, in the duffels, in the pockets of Black sailors. And so I think we can say with some pride, right, that Black sailors are indeed threatening agents because they embody the challenge to an order that would hold them to be non-citizens, but they also represent to Black Southerners, enslaved and free, right, the message, right, which is that this order is not only unjust, it is an order that is being openly, right, challenged in our conventions, in our newspapers. This is not a sidebar question. This is not an invention, right, of people who are living under the yoke of slavery. This is a national question, a political question that goes to the definition of the nation, and sailors are indeed carrying that news.
And they're litigating. They're litigating cases that have implications. Sailors who are taken into custody in Washington, D.C. This is embarrassing, right, for the national government. Lincoln is president, right, in these years, and they are challenging the fact that they have been put into what are then the familiar terrible conditions of the Washington, D.C. jail, and that information is coming out and embarrassing Congress. So they're actually litigating in this space as well. Kate?
Sure, yeah, I think so. I'll build on what Martha was saying by talking a little bit about the constitutional dilemmas that sailors posed and the ways that Black sailors and their white allies tried to exploit those in a sense to ask challenging constitutional questions that don't get resolved until the 14th Amendment, or that basically feed into where we get the citizenship provision of the 14th Amendment. So one of the reasons that Black sailors raise kind of constitutional issues is that they were traveling from state to state. So at the time, before the Reconstruction Amendments, states had far more power than they ostensibly do now to determine the fundamental rights of the people living within them. And so the argument for why it was okay for South Carolina to demand incarceration of free Black sailors who were considered citizens in their home states of Massachusetts or New York is because South Carolina could have its own rules and didn't have to observe whether they didn't have to care if Massachusetts considered this person a citizen. South Carolina could say, well, we don't, and so we're going to subject them to the same kinds of oppressive legislation that we subject our own free Black residents to, right? And so when free Black sailors from Massachusetts who are citizens of the state go to South Carolina and are forced to be incarcerated, they come back and they say, well, we are citizens. There's something called Article 4, Section 2 of the Constitution, which says that the citizens of states shall have the privileges or immunities of citizens of other states, and it's kind of a language, it's ambiguous, but they want to draw on that, and a movement develops to draw on Article 4, Section 2 to say, if you're a citizen of one state, you should be considered a citizen of all the states, and therefore what these southern states are doing, and it was South Carolina and eventually all of the slaveholding states, is unconstitutional. It violates our constitutional rights as citizens. But they're in kind of ambiguous territory here. They're making a claim on the Constitution that is not recognized very often by leading federal authorities. And so this is one of the questions that free African Americans and their white allies agitate from the 1820s all the way to the 1850s. And this is a question that actually Justice Taney weighs in on in the Dred Scott decision. It's a very little read part of his Dred Scott decision. But the question of do free Black citizens of a state have citizenship rights in another state continues to be this question. And people who are on the side of universal citizenship say we shouldn't have, as Martha was saying, we shouldn't have a nation where your rights vary that much from state to state. We need to have a baseline recognition of birthright citizenship in order to stop having these abuses when people travel from one state to another. And so that debate, again, widely known debate in the newspapers regularly. Part of the Compromise of 1850 is discussing this issue. That feeds into people's perception, or at least the Republicans' perception, of a need to have a birthright citizenship clause in the 14th Amendment.
And you allude to, this idea, going back to the language we talked about at the very beginning, of just the declarative statement. You are a citizen of the United States and of the state, right? In which you reside, just imposing on the state, this is going to be the rule. Because the consequences, as you point out, are so serious. One of the consequences, which is, frankly, in a kind of boring way, what the Dred Scott decision is about, which is about, like, can a Black person enter the federal court using the tool of diversity of citizenship? Those of you who are law students or lawyers know that there are two ways that you can bring cases in federal court. One is if there's a federal question, if you're challenging a federal statute or a constitutional provision, or challenging a state provision that you say violates the federal Constitution. And the other way is through diversity of citizenship, meaning you are the citizen of one state and you are suing a citizen of another state. And that's what's at issue in Dred Scott in the most, as I said, the most boring aspect of the case. But it shows how your citizenship, being a citizen of a state, is what triggers your access to the federal courts in our system. And so there's not even federal question jurisdiction during this period. That doesn't come until after after the Civil War and after the 14th Amendment. But what it is it's diversity of citizenship. And if you don't have state citizenship, then you can't access the federal court. So it's a great example of the implication of allowing each state to decide for themselves, right, whether they're going to confer citizenship, and the implications of it for access to federal courts. I want to talk about two things in hoping that we have time for both of them. And these really are explored in your brief, and so folks can read and learn more. I want to talk about the case of Henry Hambleton. And I also want to talk about, why don't we talk about this one first? The legal opinion written by President Lincoln's Attorney General, Edward Bates, on citizenship. I think this is in 1862, maybe. And the reason I want to talk about it is I was at the oral argument in the Birthright Citizenship in Trump versus Casa, and the Bates opinion comes up. And it's interesting, both sides are using it. One side, I think, is using it most incorrectly, but it is an issue, and the court, the justices are clearly very much aware of it. And so I wondered if you could tell us what the Bates opinion is and why it is significant. First of all, how the AG, the Attorney General of the United States, comes to write this opinion. Kate, do you want to start?
Sure. So the opinion comes out of a question. So let's just place ourselves for a second in the moment. It's the end of 1862. So the Civil War began in the spring of 1861. So here you're a year and a half into the Civil War. Congress has taken certain measures to weaken slavery as war measures. Lincoln has announced that he's going to issue an Emancipation Proclamation. He announces that in September of 1862, but it's not issued yet in sort of November, December of 1862. And the context is that once again, and another kind of recurring theme in this history is the question of whether free Black people can pilot ships, because you have to be a citizen to pilot a ship in US waters. And so this question has come up in the past. So once again, now it's 1862. I will say, I mean, with the Lincoln administration in charge, so Lincoln was elected in 1860, it's an administration that has quite different politics around slavery from any other previous presidential administration, and in all kinds of ways. So it's a kind of opportune moment to bring up this question again and see if this administration is going to take a different position. So a man, I believe in Baltimore, or no, it's in New Jersey, applies for a license to captain a ship. It comes up through the Treasury Department, I want to say, which is, and anyway, I believe it's the Treasury Secretary puts the question, no, sorry, it's Salmon Chase, puts the question to Edward Bates, the Attorney General. So Edward Bates, what do you think?
And Salmon Chase at this point is the Secretary of State, I think, is he? Because he's not on the court yet.
He's not on the court. I'm blanking on what.
I think it's Secretary of State. But anyway, go ahead.
Okay, so the question goes from one administrative department.
He asked the Attorney General
to weigh in on this question. And Bates, it's also quite interesting that Bates was a very moderate Republican from Missouri. He's not going to constitute a radical Republican like somebody like Thaddeus Stevens or Charles Sumner. He's not at all part of that wing of the Republican Party. He's very thoughtful. And actually, I was rereading this today and just thinking about how interesting it is. It's kind of dense, and I think people have had a hard time grappling with it. But as you said, Sherrilyn, it's so much on people's radar right now that I think it really bears engagement, particularly within its context, because what he's saying is very interesting and, in my view, very, very decisive. So the bottom line is, he says, free Black people born in this country are citizens of the United States. That is his answer. And he is saying that before the Emancipation Proclamation, before the Civil Rights Act of 1866, before the 14th Amendment, he's like, I'm going to look at this and I'm going to tell you what I think. And what I think is there is absolutely no reason from the perspective of constitutional law to understand free African Americans as anything other than citizens of the United States. And he goes into great detail about why that's the case, including talking about something that we haven't really had a chance to touch on, but is important, which is this legacy of the idea of birthright citizenship coming to the United States from the common law of England. So he's tracing the concept and the principle that this is at the heart of this nation to before the nation was founded, that we Americans inherited this kind of English common law. This has always been our tradition. And then he also point by point, because remember, this is also after the Dred Scott decision, he point by point kind of takes down the arguments that would say for why free African Americans should not be considered citizens. He doesn't go after Taney. He doesn't go after Taney by name. He doesn't literally say that he's overruling or going against the Dred Scott decision, but he really says, well, you might say people cannot be citizens on account of color. Well, I'll tell you why that can't be tolerated. You might say, well, on account of race as distinct from color. No, that can't be tolerated either. And so the conclusion that he comes to is our tradition is a tradition of if you were born here, you are a citizen of this country. That's why I'm a citizen, he says. Like, that's the only reason that Edward Bates, is a citizen. And it applies universally. And there are people now who are kind of splitting hairs, but the places where I have seen people quoting the Bates decision to say that there's anything kind of more complicated going on with that, the quotes are being taken out of context. And here I would really urge people to read it for themselves, to see what quotes from Bates are being used on the other side to kind of say that this wasn't a kind of universalizing declaration that all people born in this country are citizens of this country, with the exception of children of diplomats, because it's really, if you read the document, it's not there.
We'll have that in the syllabus as well. Thanks so much. Martha, I don't know if you want to add anything on that or go on and talk about Henry Hamilton.
Well, I think the thing I'll add, right, is that I hope what we've done tonight is provide some context for Bates's decision, which is to say there's very little in Bates's decision that is novel. Because the question of Black citizenship has been on the table for decades. And many of the ideas that he gives voice to in this very formal form of an attorney general's opinion is, in fact, the arguments that Black Americans have been making in the newspapers, in the colored conventions, and more. So we see, I think, the ways in which Bates is providing for students of this history a kind of culminating moment, but one that really has its origins in decades before. But I know you want to touch on passports, and passports are important because, of course, much of everyday life and the things that we come to think of as rights, including voting rights, are the purview of the individual states before the Civil War, before the 14th Amendment, before the consolidation of federal power in the wake of the Civil War. So passports, like access to federal courts, are one of those few places in which that question, is one a citizen of the United States, is actually germane to everyday life. And Black Americans are, for many reasons, among those who are seeking out passports. These are forms of identification.
Free Black
people, yes. Seeking out passports as a form of identification, as proof of citizenship, as an instrument by which, for example, Black abolitionists who are traveling in and out of the U.S. on an international lecture circuit are leaving out of U.S. ports, returning into U.S. ports. I hope tomorrow night, when you talk about Wong Kim Ark, this will resonate, because this question of what happens to one in the port is so important. But increasingly over the antebellum period, what begins to happen is that Black Americans are going to be denied passports. And the articulation, right, the trouble with sort of ferreting out why one doesn't get a passport is that it's not like a judicial opinion, right? It doesn't come with a written explication, right? It isn't a question that gets briefed. It is worked out, in the customs house in a rough and tumble way. But what we know is that increasingly into the 1850s, Black Americans are going to apply for passports. They're going to be denied passports. And some of the officials, as in the case you referred to, when they look back on that, will concede that wittingly or unwittingly, right, when you were asked the question, will you sign off on a passport for a free Black American? You were stepping into, right, a very thorny, messy, and important question, even as in the Customs House, that might seem like a minor ministerial act. That, of course, Black Americans understood the stakes in the passport, but it turns out many Americans by the 1850s understand that there are high stakes, and they are not only about the important matter of travel and coming in and out of the country, but are about many, many sort of fundamental concerns, including the ability to resist Black laws, to resist sailors' port laws, to resist the colonization movement, which is organizing to remove free Black people from the US. Citizenship is a powerful, powerful bulwark against the forces that are aligning themselves against free Black Americans.
So I want to make sure that we hit on one thing before we go. And if I'm hoping that we have time to at least get to one or two questions. And so if you have them, please put them in the Q&A. Jennifer will be monitoring them and she'll get them back to us. But I want to make sure, Jennifer, as you're doing that, if maybe you could go to the slide that had the piece that I pulled, that I had posted on our 14th Amendment social media about the understanding that the birthright citizenship provision did not apply solely to Black people, to formerly enslaved Black people and to free Black people. And Jennifer, if you're there and could put that up on the screen, I will try to read it. In the debates, and you all make reference to this in your brief as well, as do the other scholars and many others, there is an explicit conversation about whether the children of migrants, the American-born children of migrants, are in fact subject to birthright citizenship. And this conversation was going back and forth, and at some point I decided to post it. The copy I have of the hearings is not very clear, so I'll just read it. Senator Edgar Cowan from Pennsylvania asked, is it proposed that the people of California are to remain quiescent while they're overrun by a flood of immigration of, he uses an offensive word for Chinese people, the Chinese race? Are they to be immigrated out of house and home by the Chinese? Senator John Conness from California responds, the proposition before us, I will say, Mr. President, relates simply in that respect to the children begotten of Chinese parents in California, and it is proposed to declare that they shall be citizens. We have declared that by law. Now it is proposed to incorporate the same provision in the fundamental instrument of the nation. I am in favor of doing so. I voted for the proposition to declare that the children of all parentage, whatever, born in California should be regarded and treated as citizens of the United States, entitled to equal civil rights with other citizens of the United States. And that's not the only colloquy in the hearings in the legislative history on this point. And I raise it because I just think it's very important, because we are hearing so many officials say, you know, it was understood that this was just about Black people. All persons is all persons. And they had explicit conversations about the American-born children of non-citizen migrants, in this case, the Chinese. There were also conversations about who they called the gypsies at that time. All of this was debated and understood. And so the idea that we can now just spring forth 160 odd years later and decide that those words don't mean what they knew they meant, I think really requires us to really wrestle with the kind of information that we have to pull out of that history, because it's so easy to manipulate. And it's worth noting, and we'll talk about this more tomorrow night, that very often Chinese workers and Chinese Americans were the disfavored class, in the same way that we hear the way the denigration that people have about many immigrants today is the same way that conversation was unfolding at the time. And so all of this was considered. There is really truly nothing new under the sun as it relates to birthright citizenship. So thanks so much for posting that, Jen. Do we have any questions? Because if not, I'm going to go back to something that Martha Jones has talked about in conversation with me that caused me to sit back in my seat and think long and hard. What you said was that there was a hemispheric grappling with questions of citizenship, and that part of what the Black sailors were doing was going in and out of ports, not just in the United States, but in other countries. And that made me also think about like why they have been so dangerous. I mean, they had seen some things, right? And I wondered if you would just expand on that, because I had never actually thought before about the hemispheric conversation about race and citizenship and belonging. And I just wondered if you could say something about that, which I think is really important.
The conversation we've been having is set in the age of abolition, which is to say that slavery has been a long-standing institution in nearly all of the Americas. But by the time we get to the debates that we're referencing, slavery is ending in many parts of the Americas. In much of the Spanish South America by the 1820s, for example, in the British Caribbean in the 1830s, in the French territories in the 1840s. And indeed, those same Black sailors who are regarded as a danger in US ports are not only in US ports, they are in Havana, and they are in Veracruz, and they are in Rio de Janeiro, and on and on. And they are part of a global understanding, not only of the imperatives of slavery and freedom, right, but of denizen versus citizen. And they come away from those travels. And I write about a man named George Hackett, who travels to those ports and meets not only free Black sailors, but observes the way in which in many port cities, free Black people are now enjoying the standing of citizen, and comes back to the US, comes back to Baltimore, and commits the rest of his life to this struggle that we have visited tonight, because he is affirmed, because he is informed, he is fueled by what he learns, and because those conventions and those newspapers make those stories, make those insights, including, of course, the critical story of Haiti and its independence, part of the Black American consciousness. And in that way, we can appreciate that the ways in which figures like Roger Taney are really resisting not only what is in front of him, right, but what he knows. And Taney knows a great deal about what is happening across the hemisphere. And it doesn't bode well, right, for those who stand with slavery and who are going to continue to oppose full citizenship for Black Americans.
Thank you so much for that. So thought-provoking. It looks like we have a good set of questions, and Jennifer's been kind enough to send them to me, so I'll just read a couple of them. One of them is, when Black babies had to take on the status of their mother, was there any analysis of this law when the 14th Amendment was being constructed? I'll leave that one there for a second. Second question. Will you discuss the citizenship granted to Puerto Rico after the Spanish-American War in 1898? I'm concerned that this current administration will question our citizenship.
I mean, I think on the first question, if the questioner is asking about how in slavery the status of the child was based on the status of the mother, so if the mother was enslaved, then the child would be enslaved. There's a chronological change here. So the 14th Amendment is being discussed after the 13th Amendment, which abolished slavery. So they're operating in a world, the people who are framing the 14th Amendment are operating in a world in which they're assuming that slavery is outlawed and that those old laws about there's nobody's supposed to be enslaved anymore in the United States. Now, I mean, there's a whole other story to be told about how it wasn't that easy to get people out from under enslavement, and that process itself, which unfolded mostly during and a little bit after the Civil War, was very fraught. But they're operating with the idea that there is no more slavery, everybody's free. And now what they're really grappling with is, okay, to what extent now I'm talking about legislators, were asking themselves, to what extent do we need to go beyond just saying there's no longer slavery in this country to saying affirmatively, okay, now who are citizens? Is anyone who was born here now going to be considered some sort of alien or denizen or something other than a citizen? Or are we really going to affirm this principle of birthright citizenship? So they're really dealing with a world in which they're assuming that slavery is over and they're moving on to different kinds of questions.
I think the thing that I would add is that the question reminds us that there are two sort of major concepts that determine status and membership in a body politic coming out of the 18th century. One is this principle of the soil, and that is the birthright principle, right? You're born on the land, you are a citizen of the place. But the other alternative, and one that the framers did not adopt, would have been a citizenship by blood, right? And there we hear the echoes of the womb laws that have required children of enslaved women to follow the status of their mothers. It might have been that the framers created a provision that required if one is a citizen, if one's parents are is a citizen of the parents are citizens of the United States. That didn't happen in 1868, and instead that principle falls away. And birthright is the choice that the framers make in 1868, and it is the position that Black Americans have long held.
Any quick thoughts on Puerto Rico?
I'll just, if I could, because I think it's a much longer discussion, I want to commend the work of scholars like Sam Ehrman, who have worked so carefully on that, and I hope you can share Sam's work. But I appreciate the spirit of the question, which I think many of us are asking, what is it that this administration might aspire to undo, right? And I have long been of the view, right, that the challenge to birthright by challenging the children of so-called unauthorized immigrants is the low-hanging fruit. And if the administration is able to succeed in this, then we really do face a question about what else might they look to undo, whether it is by fiat and an executive order, whether it is by an act of Congress, whether it comes about by way of litigation that ends up before the court. We rightly, I think, all share a concern about what might follow. Yeah, and we'll talk about this a great deal tomorrow night as well. I'm so grateful to you both. This was such a rich conversation. I mean, I'm a 14th Amendment nerd, so I could do this all night. But, you know, one person asked, how do we stay positive? Thanked us for this education about how do we stay positive. I think we have to, I don't know that the call for us is to stay positive. I think the call is for us to stay alert, awake, woke, if you will, and to stay vigilant. Part of the reason I wanted to do this is because this implicates the citizenship of every American. And just as that last question, you know, suggested about Puerto Rico, we have to wonder what comes next. And we'll talk tomorrow night about, you know, in the past when, these processes have resulted in the stripping of citizenship and so forth. We do need to be completely aware. We need to have the kind of imagination that imagines what could be, and we need to be ready to push back, to fight against it, to protect our citizenship as Americans. But it begins with knowledge.
It begins with knowing where it comes from. It begins with knowing what the context was in which these principles were developed. It comes from feeling confident that you can stand toe to toe on this. And I think for such an important concept, like how do we become citizens? All of us who are on this webinar tonight, we're 14th Amendment Americans. You know, our conception of who we are, our access to equal protection of laws and due process, and the words no state shall, that we're protected against the state, all comes out of the 14th Amendment. And as we continue our webinars over this year, you'll learn more about the 14th Amendment. But that's who we are. And we are ill-equipped to protect ourselves as 14th Amendment Americans when we don't know about the 14th Amendment. We spend a lot of time talking about the First Amendment and the Second Amendment. People will know how to say, even joking, I plead the Fifth. You know, we have some sense of some of the amendments, but we are woefully uneducated and ignorant about the amendment that is so powerful and so much shapes our lives and our conception of ourselves as Americans. So I want to thank Professors Kate Masur and Martha Jones for being with us tonight, for sharing their brilliance. I thank Jennifer Osias for supporting and helping us put this whole webinar together and get it out to you. I want to thank the IT team at Howard, and I wish you all a great night. If you can join us tomorrow, I hope that you will. There's going to be really new and exciting information and a fantastic group of scholars who will be with us. You're going to get all the information and the data that you need to follow up, but stick with us, be with us throughout this year as we open up this portal to constitutional understanding, not only for lawyers and law students, but for all of us. Thanks so much. Good night.